Here, I am tired of all this talk that a Republican Party who supports Roy Moore down in Alabama has lost its soul. That's a bunch of bull. We'll talk about it when Freedom returns at 5.
Good morning, Dan and Amy. So the Supreme Court taking up a couple of high-profile cases this week. Of course, they'll hand down their holdings next year. One of them is sports gambling. And we've got a Georgetown law professor, Randy Barnett, who's going to join us. Because I got a friend who's interested to know if we could see sports books legalized across the country and not just limited to Vegas.
Yeah, that would be good news.
My friend wants to know.
Yeah.
My friend is interested. So I'm going to try and find out what Randy Barnett thinks about that. But, of course, the highest profile case is the Masterpiece Cakeshop case out of Colorado. And the questioning from the Supreme Court justice was interesting. You can't read too much into it in terms of what their ultimate holding may be, because they play devil's advocate and ask probing questions of both sides and so forth. But it was interesting that in this case of Jack Phillips, who is the proprietor of Masterpiece Cakeshop in Lakewood, Colorado, that Alito, first Kennedy of all people, the author of the Obergefell op-ed, Kennedy saying, tolerance is essential in a free society, and tolerance is most meaningful when it's mutual. It seems to me that the state, in its position here, has been neither tolerant nor respectful of Mr. Phillips's religious beliefs. And then Justice Alito added to that, suggesting that in a 2014 case, this Colorado Civil Rights Commission, which has sanctioned Jack Phillips for not being willing to design a cake for a gay wedding, in a 2014 case, the same commission found a Denver area bakery which refused to create cakes promoting traditional marriage did not discriminate against the patron's Christian religious beliefs. So is this arbitrary and capricious with respect to the commission? Roberts also feared the slippery slope of where anti-discrimination laws like Colorado's, as the commission is interpreting them, could lead in terms of forcing specific performance, infringing upon people's constitutional rights. For his part, Jack Phillips, in an op-ed in the USA Today, said, "What I design is not just a tower of flour and sugar, but a message tailored to a specific couple and a specific event. A message telling all who see it that this event is a wedding and that it is an occasion for celebration." And ultimately what he's describing, arguably from his perspective and those that support his freedom in this area, is that his designer cakes are artistic speech, and therefore he has a First Amendment right. He shouldn't be forced to speak in a way that he doesn't want to speak. For more on these topics, we're pleased to be joined by the aforesaid Georgetown law professor, Randy Barnett. Randy, thanks for joining us again. Appreciate it.
Nice to be there with you, Dan and Amy.
And so how about that sports gambling case first? Where's that going?
For Dan's friend.
Yeah, for my friend.
I didn't. I was sort of getting ready for other matters, including attending argument in Masterpiece Cakeshop yesterday. So I haven't read reports even of how oral argument went, and I haven't read the transcript. It could be the more important of the two cases because it's really about whether federal law can be used to make states pass laws. We thought we knew the answer to that question was no, that would be considered commandeering, but New Jersey is putting that to the test. The question is whether New Jersey can be forced to keep a law on the books that it doesn't want to have on the books anymore, because that's what the federal government wants it to do, what Congress wants it to do. So it's actually a pretty important federalism case, and I'm quite interested to see how it may come out.
How do you think it's going to come out? I mean, what is
well,
your gut tell you?
I make a practice of not predicting how any of these cases are going to come out, and that includes the Cakeshop case, where I do have some opinions about how the oral argument went yesterday.
All right, well, let's hear those opinions. What do you think the justices were telegraphing?
Well, I went into the case with a brief on behalf of the petitioner, on behalf of Jack Phillips, an amicus brief that argued that it was a compelled speech case, or it should be construed, it should be dealt with as a compelled speech case, not a religious free exercise case, because he was being compelled to state a message. And I would have thought before the argument that was the path of least resistance for 5 justices should they want to side with Jack Phillips. I walk out of the argument feeling differently about that. first of all, there were a lot of slippery slope questions about the compelled speech theory that counsel had a difficult time answering. I don't blame counsel for that. I think it's difficult. So there's that. So and I think Justice Kennedy had some slippery slope problems with the compelled speech case. So it looked like Jack Phillips wasn't going to have a good day. And then when it came time for Colorado to argue, Justice Kennedy chimed in with the words that you've already quoted for your audience. And those were the words. I actually didn't bring a notepad with me into the courtroom. You're not allowed to bring any electronics of any kind. But when I heard him say that, I actually reached for my wallet and got out a business card so I could write those words on the back. Those were the key words of the oral argument, where Justice Kennedy said that he did not think that Colorado had treated with respect. What did he say? You got the exact wording, so why don't you read the...
Yeah, he said, tolerance is most meaningful when it's mutual. It seems to me the state in its position here has been neither tolerant nor respectful of Mr. Phillips's religious beliefs.
Right. So that brings the case back to free exercise, away from compelled speech. It suggests where he's coming from. And then it became apparent that several other justices jumped in or then intervened to reinforce Justice Kennedy's view on this. Justice Gorsuch asked a question about the commissioners and whether they seem biased. Justice Alito made the observation that you pointed out about how the statute has not been applied in a neutral fashion. And Chief Justice Roberts read back or paraphrased what Justice Kennedy said in Obergefell about the fact that opposition to same-sex marriage was an honorable belief. So those three justices seem to see that Justice Kennedy might be moving here, and that would be a very narrow win for the bake shop owner, for Jack Phillips. And I can explain why this is so narrow. Much narrower than compelled speech and much narrower than other free exercise claims might be.
Yeah. Well, and that would be a bit disappointing because I found I think the argument you're making, as well as the argument that Professor Robbie George from Princeton made, that he distinguishes this in an op-ed he wrote in the New York Times. Our point is not that forcing people to sell a product or service for an event always compels them to endorse the event. It's that forcing them to create speech celebrating the event does. And if that is not something, I'm sorry.
Robbie and I were on the same brief in this case.
Okay.
Making that argument.
Okay. Well, so if the court does not hold that does not actually support that argument in its holding, what are the implications of that more narrow read on religious conscience that you were talking about?
All right. Two implications. First of all, the narrow reading is, as telegraphed by Justice Kennedy, it's based on a previous Justice Kennedy opinion in which he argued that the city of Hialeah was going after the Santeria religion when it crafted its neutral law. And the record showed a sort of anti-Santeria bias in Hialeah when it made its law. And that was enough, he said, to take it out of the Smith case, which says that laws of general application will just be applied to religious dissenters. That was a Justice Scalia opinion. But Justice Kennedy's opinion said, look, if it looks like this law, however general it may be, is not being applied in a neutral fashion, or it really isn't neutral, if the record shows that, then it's unconstitutional. And that seemed to be what now four justices were sort of alluding to here, that the Colorado civil rights law, though it was general in application, it was general in drafting, it wasn't being neutrally applied here. And that would make it unconstitutional. But that would only apply in cases where there was a record of such non-neutrality as there apparently is in Colorado, although neither party had stressed that idea. And there might not be anywhere else. So it's very limited because it'll only apply when you can show that kind of bias, anti-religious bias, and government officials are usually careful enough not to show that. The reason why this still could be a good thing is because it might mean the court just doesn't reach the compelled speech issue at all. And it would be better for those of us who think that's a good argument for it not to reach that issue than to rule against it. If they were to rule against it, then I think it's Katie bar the door in going after Christian dissenters across the country and making them bend their knee.
Well, absolutely. That's a concern that essentially Roberts raised with his example of pro bono Catholic Legal Services being forced to represent somebody they didn't want to represent.
Right. So if they go off on this narrower theory, most likely they wouldn't even reach that idea, and that would leave it to future litigation and future justices in the future court. That would be better than losing on that issue. It would be a narrow victory for the baker here, and it wouldn't apply. There are a few other cases where it might apply, but it won't apply that generally, and yet the issue will still be preserved for future litigation.
But don't you think it'd be, I mean, if the cake maker wins, and I'm on the cake maker's side, but doesn't it seem discriminatory if the cake maker, then you might have other, places where there's, artists express themselves, such as makeup artists, people in the hair industry that say they do not want to be a part of a same-sex marriage because of their religious beliefs.
Well, if they use the theory that was being discussed at the end of the argument, they'd only be protected if it looks as though the people who are enforcing the law are going after religious dissenters by their statements or by their actions. So all those folks would be protected regardless of whether they were engaged in artistry or not, if that's what it looks like on the record. But I think most government officials are pretty careful not to make a record like that, so it wouldn't apply very broadly.
Where was Gorsuch during oral arguments?
Sitting on the very far right of the court. I'm sure that's. He tried to get a few words in edgewise. Other justices jumped in, and he then deferred to their speaking. But he's the one that raised. One justice had raised or maybe it was he who raised the idea that one of the Colorado commissioners had expressed very anti-religious bias. And then he pointed out a second one seemed to have said something similar to that. So he was making that observation, and I can't recall the other comments that he made. One of the things that was notable about oral argument was how much the liberal justices wouldn't let counsel answer questions. It's very typical to interrupt counsel's answers. I argued in the Supreme Court. I was interrupted. But they usually get a portion of the answer. They let you get a portion of the answer out. And there were many times in which a question was asked, counsel for Jack Phillips tried to answer and never got any part of it out before another question was asked, which was odd. And then the most extreme example of that was on rebuttal, where the counsel for Jack Phillips had reserved 5 minutes for rebuttal, and she got up, and the point of rebuttal is to rebut what the other counsel have said. And before she could say a word, Justice Sotomayor posed another long, convoluted question and hypothetical, essentially making her own argument, preventing counsel from rebutting. Eventually, once that was over, counsel did get her rebuttal in, but I just was floored.
That's
the justice stop a counsel from rebutting the other lawyers.
That's the new protocol of the left. You silence speech however you need to silence opposing viewpoints however you need to silence them. They're just applying campus politics to the court, I guess.
You just don't see that at the Supreme Court, where argument is generally courteous, regardless of what side you're on. Even if it gets heated, it's not personal. This wasn't personal. But no, the discourse at the court has always been very, very at a very, very high level. This really was this argument was a bit startling when it came to courtroom decorum.
It's interesting to note, but it's a brave new world, and no institution is insulated, apparently. He is Randy Barnett. He is Georgetown law professor. Randy, thanks so much for joining us and for your insights on the oral arguments on that Masterpiece Cakeshop case, and we'll get back to you.
It's always good to be talking to both of you.
Thanks very much.
Thanks, Randy. And he joined us on our turnkey.pro answer line.
The more you listen,